May I start, sir?
Yes, yes.
Okay. So, hello everyone. I Komal Sharma. Welcome you all today. Law Insider, which is a top-rated legal media production company, which is involved in creating legal awareness in the society and also different webinars and certificate courses. Let us begin with a brief introduction on our crowd prevailing topic, that is decoding the hijab role. At the beginning of the January 2022, a dispute pertaining to school uniforms erupted in the India, which is in state of Karnataka, where some Muslim students of junior college who wanted to wear hijab to classes were denied entry on the ground that they are violating of college uniform policy. Over the following weeks, the dispute spread to other schools and colleges across the states. The student from the government-run pre-university college for girls, Udupi, approached the Karnataka High Court seeking the permission to wear hijab or headscarf instead inside the classroom. As per them, it is fundamental right of students to wear a hijab guaranteed under Article 14 and Article 25 of the Indian Constitution. Hence, the controversy occurred. Yesterday, uh, Honorable Honorable Karnataka High Court upheld the ban on hijab and cleared hijab status in religion. Further, by not taking much time, with pleasure, I would like to introduce our immensely special guest, Mr. Abhinav K. Shukla, sir. Sir is an assistant professor in Hidayatullah National Law University. Also, Mr. Shukla, sir, has been mentoring the CLAT aspirant since 2015 and has worked as a faculty member and national anchor with leading CLAT preparation institution, IMS, India, Mumbai, and career launcher, New Delhi. He has also worked as an assistant professor of law in Amity University, Chhattisgarh. Sorry. So proceeding further, our first question of the topic is, what are your first thought of issue of hijab and judgment of Karnataka High Court, sir?
Thank you, Komal. I hope I'm audible.
Yes, sir.
So to begin with, to start with the judgment, or the issue, I want to, read on or bring in the notice few lines that were specifically cited by the Karnataka High Court yesterday, while pronouncing the judgment on the case of Reshma versus State of Karnataka. So, as briefly stated by you, the issue pertains to a government order dated 5th of February 2022, which allows or prescribes a set code or code of uniform for the government colleges, government schools, which is in Karnataka. If you would have read, it is the PU University, that is pre-university, which is, basically the schools. So the controversy was with regards to the order that mandated, that allowed the colleges to prescribe uniforms. And if a uniform is prescribed, if we go by the definition or the word or the general perception of the word uniform, it has to be equal for all. And in that regard, when the Muslim women were denied entry in the respective colleges, the pre-university, so they had approached the Honorable High Court with the writ petition that it violates their right to wear hijab, and it is a part of their freedom of religion guaranteed by the Constitution under Article 25, and it is an essential religious practice which the state cannot deny, and this happens to be a violation of fundamental right. This was the primary claim. We will be looking into the detailed arguments by the petitioners, detailed claim by the petitioners and the respondents, and then what the High Court had said on these issues. While declaring the hijab not to be an essential religious practice, yesterday the Karnataka High Court said few things. To name a few, the court said that prescription of uniform dress code for all students serves constitutional secularism. It serves the purpose of constitutional secularism. If the practice is renounced, as in if the practice of hijab is renounced, it is stopped, the religion in question, that is the Islam, would not cease to operate, or the religion would not cease. Those not wearing hijab may not become sinners to the religion. These are few observations that were made by the court in this case. And to clarify one particular thing, which we have been seeing in few headlines since yesterday, we have seen it today as well, that hijab has been banned by the court. To clarify that, hijab has not been banned by the court, not at all banned. It is just that you have to adhere to the policy of wearing uniform while going to the schools. Hijab has not been declared as illegal. Wearing hijab has not been declared as unconstitutional or a wrong practice. It is just that the claim was that we should be allowed to wear hijab while going to these schools because it is an essential religious practice under our religion. And if the state government, through the government colleges, schools, is prescribing a uniform and not allowing us to wear hijab while we are going to the schools, this is violating our religion. This is violating our right to freedom of religion, which is guaranteed to us, which is given to us by Article 25. So looking into the primary observation, that what is the judgment about the impact, about the observation, the approach of the court, it can be said that it's a very sound judgment, constitutionally very, very sound judgment, because the petitioners had cited more than 15 cases from the Supreme Court, from the Kerala High Court, from the Madras High Court, or for that matter, even from the Supreme Court of South Africa. The court has considered all the findings, observations, and bindingness through which the Karnataka High Court is also bound, especially looking into the Supreme Court judgments. And there were also judgments which were referred to and cited by the respondents. The court has responded to the affiliation, the relation, the association of this matter with the issues that were involved in all the other previous judgments that we will be looking into some of them. And the court had come up with this reasoning that, as I said, that wearing hijab is not an essential religious practice under the Islamic faith, and therefore it cannot be claimed as a constitutional right under Article 25. So that if a school, if you are going to the government school, if you are a student of a government school, and if they are prescribing uniform, you have to adhere to it. You have to go to the schools in the uniform, and you cannot claim that, you have the right to wear hijab. You can continue the practice of wearing hijab after your school hours, before your school hours, in all other places, public places, personal spaces, but not in school. Now we will analyze that how has the Supreme Court come to this particular conclusion, and what is the matter that the the High Court, the Karnataka High Court said that you cannot claim it as a right while you are going to the schools, and you have to wear the same uniform which is being worn by all other girls, and you cannot claim a distinction or an exemption from this. So this is about the primary observation that I can say about the judgment. Now we will be looking into that, what have been the claims and how the court has come to this particular conclusion.
Okay, sir. So our second question is, since the Karnataka High Court has outrightly rejected the claim of wearing hijab being an essential religious practices, what is the issue of essential religious practices, and how does it impact the freedom of religion in India?
So when we go into the judgment, and when we look into the judgment, when we look into the issue, the matter of essential religious practice, and the court declaring the practice of hijab not to be an essential religious practice, and that is why your claim is rejected. So first we look into that, what do we mean by this essential religious practice, how it is protected by the Constitution, and what it has to do with the freedom of religion that we have in the Indian Constitution, and what has been the impact of this essential religious practice in other judgments that we have had in India, and its impact on the society, on the culture. So when we look into the Indian Constitution, it gives protection to the right of freedom, right to freedom of religion, as in, I, being a person living in India, have the right to practice, profess, and propagate my religion. Practice as in, profess and practice as in my faith, that I can have belief and faith in any religion. I can practice all the practices that are associated with my religion, and nobody, the state cannot stop me. I cannot be restricted and stopped from doing that. And also the right to propagate, that is, to communicate and make people aware about my religion. These are all the protections which have been provided by the Indian Constitution. But this is a fundamental right which starts with a clause stating that subject to public health, morality, and public order, health and morality, which means This is also not an absolute fundamental right. And the state, when we say state, means the government, the central government, the state government, they can interfere with my religion, my right to practice, profess, and propagate my religion, if it is a matter of, something which can disturb the public order, something which has relevance with health or morality. So in this regard, it cannot certainly be said that my right to practice religion is an absolute right. It is subject to reasonable restrictions. Now, what are these reasonable restrictions, and what is the relation of it with essential religious practice? So the Supreme Court of India in 1954 had come up with this particular notion that only those practices will be protected under the Indian Constitution which are essential religious practices. The Supreme Court said this in the case of Commissioner Hindu Religious Endowments Madras versus Sri Lakshmindra. So now what are these essential religious practices? The court propounded this and said that it is not that under the name or under the ambit of you have the freedom of religion, you can exercise all the practices that you want, or all the practices that are being, practiced or being exercised by you or the members of your religion. And therefore, only those practices will get protection which are essential in nature. Now, what is this essential aspect? Essential as in, if you remember the statements which I cited earlier, that the Karnataka High Court said, those practices which, if seized or if not allowed to practice, your religion won't be seized or your religion won't be impacted. Just for example, if we talk about the nikah system of marriage for the Muslims, it is an essential religious practice. And if that nikah system, which is a part of Islamic religion, if you are stopped from practicing that particular practice, it can be said that the religion will be impacted and it will be a question on the continuation of your religion. Similarly, we can say that the ceremony that we have in Hindus for the marriage, this can be considered as an essential religious practice. The 5 Ks of Sikh religion, which starts with kesh, that is uncut kesh, that they have to keep those in the form of turban that they keep, the kirpans that they have, these are considered to be essential. So these are those practices which are considered to be so substantially important for your religion that if you will not practice these, or if you will not exercise these things, then your religion will be in question. So the Supreme Court in a lot of cases has analyzed that what all practices can be termed as essential or essential religious practice under the Indian Constitution or not. Before hijab, if we go by the previous 2 contemporary judgments, we have those in the form of the triple talaq judgment, the triple talaq verdict, and that of the Sabrimala verdict, which was with regards to the entry of women in the Sabrimala temple. In both these cases, the court found that in triple talaq, the court said that the practice of triple talaq is not an essential religious practice under the Islamic religion, which means the same. If people of Islam are not allowed to practice triple talaq, it is not going to impact or affect the religion of Islam, about the existence and about the continuation. The same was also brought into question when it was under in the entry of women in Sabrimala issue. That if the women who are not allowed to enter, the women between the age group of 10 to 50 are not allowed to enter, if they are allowed, then it is not going to impact, the continuation of religion. And that is why in hijab case, also the Karnataka High Court emphasized on the fact and said that if hijab is not being practiced, and if you are stopped from practicing or stopped from wearing hijab while you are going to schools, then your religion won't cease, your religion won't be impacted, your religion won't be affected. So this is a brief about essential religious practice, that those practices which are extremely important and substantial for your religion to continue, and its affiliation is important to continue for the growth or for the continuation of your religion. And now the question comes that on what basis the court can find out that whether a practice is essential or not, whether a practice is important and significant to a particular religion or not. Then we can say that reliance of something being an essential religious practice or not, whether any practice, because see, why the court, now coming to the question that why the court had to come up with this kind of restriction that only essential religious practices will be allowed, because of the fact that you cannot come up every day and say that I want to practice this particular thing because I have the freedom of religion. Taking the example of hijab, when the girls in this particular case, they wanted to enter the school wearing hijab, the people from different religion, they started coming up in different dresses of different colors, stating that we also have the freedom to enjoy our religion. So this distinction is necessary, and that is why the court had come up with this practice of essential religious practice, that we cannot allow everything under the sun to be covered as a part of your freedom of religion, and only those things to be covered which are essential for your religion. Now, what are the factors on which the court relies, or the judiciary has been relying upon to find out whether a practice is actually essential or not? The first and most important aspect in this is the historical affiliation of a practice. In law, there are different types of laws that are given recognition. The most important and significant, or the common one that we know, is the legislative laws, or laws drafted by the parliament legislature. But there is also an important recognition of law which is known as customary laws, which are known as customary laws. So the constitution recognizes, the law recognizes those practices which have been which have been practiced by the people of a particular religion since ages, since a considerable time. And it is evident in the history that that particular practice is essential to affiliations, norms, rules, regulations, or ideologies of a particular religion. So the historical aspect is considered. In this case, the court said that it is nowhere evident that the practice of wearing hijab has been, historically evident in the religion of Islam. Even if we consider the time period from 1950 till present, the 75 years after independence, it cannot be said that each and every Muslim women have been wearing hijab while they go to the education institutions. And the court relied on this fact that there is a lack of historical affiliation of the practice of hijab. The second is the religious text. While analyzing that any particular practice, because it's not simply that the court can accept the arguments that because we want to practice, it is not about what you want to practice, or it is not about because you have the freedom you can enjoy, or you want to enjoy or get the benefit of enjoying any practice under the name of religious protection or freedom of religion. So the court analyzes and relies on the religious text to find out whether a particular practice is affiliated to or has a mention in religious text or not. What are the various religious texts? If we talk about the Islamic religion, Quran is considered to be the holy text of Islam. In the matter of triple talaq, the Supreme Court analyzed the provisions, the quotations, the sayings from Quran, and then had come to a conclusion that Quran nowhere says that triple talaq is a mandatory practice and is an essential practice. And the same happened in the case of hijab as well. There were various religious texts that were cited by the petitioners, in this case from Quran, and it was claimed that on the basis of this we can say that the practice of hijab or wearing hijab is essential and is necessary and is asked by our religion to do. And if we don't do that, we will be considered as, sinners, or we'll be considered as violating something which is mandatory for us to do under our religious text, Quran. The court, in fact, quoted, if we read the judgment, in the judgment, the court has specifically mentioned a paragraph in which they have said Islamic religion asks for women to dress in such a manner that it is considered, decent, and it should not be in such a manner that it is against the modesty of women. But in nowhere prescribes the mandatory aspect of wearing hijab while being in public places or going to education institutions or whatever it is. And therefore, substantially relying on this religious text of Quran, the court found that wearing hijab, or the practice of wearing hijab, is not an essential religious practice. And the third in this regard is further judicial pronouncements. So there have been a lot of various judicial pronouncements in India, wherein the court has, again and again, the first one which I quoted from 1954, where the Supreme Court had kind of propounded it. And then further, there have been a lot of judgments in which the court has relied and analyzed whether a practice is essential religious practice or not. To quote a few, in the case of Muhammad Hanif Qureshi versus State of Bihar, 1958, the Supreme Court said that cow slaughter is not an essential part of practice of Islam. So this was again a controversy, that under the directive principles of state policy, the state is directed that you should make certain laws to, stop or try to stop the slaughter of other cattle such as cows. And the matter was brought to the Supreme Court that if the state makes a law in this regard, then it will be a violation of a practice of Islam. So the court said that it is not an essential religious practice. Next in this regard is Dr. Ismail Faruqi versus Union of India case, 1994. In this case, the court said that mosque is not an essential part of practice of Islam. So in this case, again, the court relied on the fact, and court accepted the fact, that namaz is an essential religious practice of Islam. But mosque is not an essential religious practice of Islam. It's a place where people gather to offer namaz, but it cannot be considered as an essential religious practice. Another case is Afsal Ansari versus State of UP. In this case, the court said azan is an essential part of practice of Islam, but azan via loudspeaker is not an essential religious practice. So while azan is an essential religious practice, but that through loudspeaker is not. In the case of Javed versus State of Haryana, the court said polygamy and procreating multiple children is not an essential religious practice. Similarly, Dargah Committee Ajmer versus Sayyid Hussain Ali, the court said banning entry of other sects in Dargah is not an essential part. And a very recent judgment of 2016 is where the court said that banning entry of women in Dargah is not an essential part of essential practice of Islam. The case is Nurja versus State of Maharashtra. And after that, the one which I already quoted was Shaira Bano versus Union of India, where the court said triple talaq is not an essential religious practice. So these are various judicial pronouncements based on which the court analyzes each and every practice from case to case basis and does not generalizes that all these things which comes under this category will be considered as essential and non-essential. The court never generalizes. The court has a few guidelines and it relies on few factors which I said, such as relying on the religious text, relying on the historical aspect and the importance and significance for how long it has been practiced till now. So this is the element of essential religious practice, which forms the most important and substantial part of the judgment of the Karnataka High Court in Hijab row, on the basis of which the court said, because the claim by the petitioner, the most important claim by the petitioners were this, that it is an essential religious practice and we are not allowed to practice. We are stopped from practicing it, and therefore we should get this protection, to which the court said it is not an essential religious practice. But again, I am repeating on the fact that the court did not ban the practice of, unlike the case of triple talaq, the court has not banned the practice of hijab. It is only that you cannot claim it as a right while you are going to a government school or college where they are asking you to mandatorily follow a particular prescribed uniform.
Okay. So our third question is, it has been a matter of public disorder that being an Indian, one has the right to choose whatever they want to wear. Isn't the judgment against the notion of right to choose your own manner of clothing?
Considering this particular question, that whether the court has or the judgment will impact the right to choose whatever you want to wear or not, or whether the court has stopped you from exercising such rights, or is it about the right which you have to choose what to wear, what not to wear, is something which is not protected under the Constitution. So first of all, yes, it is a protection. It gets the protection, and it was largely claimed in this particular case that it is the order by the government not to allow the women, the girls, to wear hijab and sticking to the uniform will be or is violative of Article 19(1)(a), that is freedom of speech and expression. So I, being an Indian citizen, has the right to express myself, and right to expression also includes what I am wearing. It is my choice what to wear, what not to wear, and nobody can decide that what kind of clothing I want to follow or I want to wear. Absolutely right. But then comes another question, whether this right is an absolute right. The answer is certainly no. The court has nowhere said that you don't have the right to choose what you want to wear. If you want to wear hijab in other places, in public places, in your own home or personal spaces, you're absolutely free to do so. And in that manner, you are allowed to exercise your freedom to choose what to wear, what not to wear. But there are certain reasonable restrictions. For example, for instance, if you are going to school, you have to follow the orders, the rules and regulations which the school has prescribed. To wear a uniform, to come in certain uniform, it is a reasonable restriction. And therefore, none of the fundamental rights or none of the rights can be claimed as absolute in nature. And so is the case with right to choose what to wear, what not to wear. So absolutely, the court has nowhere said, or the judgment is nowhere going to stop you or your right what to wear, what not to wear in all other aspects. But covering those in reasonable restrictions, if I have taken admission in a school, I have to abide by the rules and regulations that they are prescribing. Now, coming to the question that why in schools even? Because there is a rationale behind it. There is an objective, there is a reasoning behind it. And I'll read the particular order that the government of Karnataka had issued for prescribing the uniform, or the disputed order out of which the dispute had arisen. So the government order dated 5th February, it does not prescribe any dress code, and it only provides for prescription of uniform in 4 different types of education institutions. So what the government order did, the government order only classified 4 education institutions, that these are the different types, and this is how uniform can be prescribed in these institutions. The first, in government schools as prescribed by the government, a uniform can be, students should compulsorily adhere to the dress code or uniform in government schools as prescribed by the government. Number 2, in private schools as prescribed by the school management. Now, this is another big question. Whether we claim, or whether can anyone claim, if they have taken admission in Delhi public school and the school has a specific uniform, everybody has to stick to it. Everybody has to follow. And that is why the government also said that in private schools as prescribed by the school management. This has nothing to do with the state or government. So keeping it aside, but yes, this is also an important fact to be considered, that the question and the dispute over here is because it was a government school. But if you take admission in a private school, you have to stick to the uniform that they are prescribing. And you cannot claim over there that it is my right to choose what I want to wear, and I'll come to school only in my casuals or my religious dress. Because then this is something which can be claimed by everyone, by people of every religion, by students of every religion. The third distinction that the government made in the same order was in pre-university colleges that come within the jurisdiction of the department of the pre-university, which is the case in the present matter, as prescribed by the College Development Committee or College Supervision Committee. And in this case, the College Development Committee prescribed a uniform and said that there is a uniform, you cannot wear something, in addition to the uniform. And the last was, wherever no dress code is prescribed, such attire that would accord with equality and integrity and would not disrupt the public order. So now it was alleged that this particular government order is taking away our right to choose what to wear, what not to wear. If to say that it is taking away only for a limited period of time under a reasonable restriction and something which is allowed. And that is why the government specifically said, the court in this case specifically said that principle of or the rule of uniform being prescribed by the concerned institution is a reasonable restriction and should be allowed. And you know what was also a claim in this case? The students claimed that, or the petitioners claimed that, we will abide to the uniform, but we want a reasonable accommodation. Now, what is this reasonable accommodation? Reasonable accommodation as in, we will wear the uniform in addition to the hijab, and the hijab would be of the same color as that of the uniform. To which the court said that the reasonable accommodation may lead to social separateness. The very reasoning, the very rationale behind why the government prescribed uniform was this, that there should not be any social separateness at the level of schools. The people, the students, right from primary schools, middle schools, and so on, they will be in a position to identify, to classify, and to differentiate that people are divided and people are different, people are separate, because few people are wearing different uniform or different kind of dress or attire, and we are different in that regard. So at the level of schools, the social separateness is not acceptable. This is what the court said, and that's why I said that the claim of reasonable accommodation, which you are claiming on the basis of your right to choose what you want to wear, is not something which can be accepted on constitutional grounds. Also, there was a claim that the hijab is also allowed in the Kendriya Vidyalayas. The court said that that is completely different matter here. Right, as of now, we are not dealing with, or we are not concerned with what is the prescribed uniform of Kendriya Vidyalayas. It is a school which comes under the Union of India, and we are a federal nation. The state governments and the union governments are having all the constitutional autonomy power to describe, to form and to make rules and regulations and laws on their own. So it's a different matter. We cannot do a comparison in this regard. Therefore, when it is claimed or when it is said that due to this judgment of the court, or if it is not allowed to wear hijab, your right to choose is violated. Right to choose what to wear is violated. This is a very wrong claim or notion that we can say, because it is not an absolute right. Wherever you are going, you have to abide by the institution. You cannot go to the armed forces or the police forces and claim that you want to, have a particular attire. Even for that matter, in the government services, in various civil services, there are different prescribed dress codes. There are different prescribed attires. At some places it is well defined, at some places it is kept under a broad classification. So you absolutely have the right to choose what to wear, but it is not absolute in nature, and you can claim it, but subject to certain prescriptions, subject to certain restrictions, such as if you are going to education institution and if it has prescribed a uniform, you have to abide by it and you have to follow that particular. So this is a particular approach of the court when it was claimed that it is against our right to wear or right to choose what we want to wear or what we don't want to wear.
Okay, sir. So now fourth question is, in the past decade, we have seen some historic judgments, as you mentioned before also, on the matter of right to religion and women right. Uh, to the few, a name the Sabrimala verdict and triple talaq verdicts. So in the line of this, where do you see the judgment in the line of this, where do you see that the judgment on hijab and its impact on the woman right?
Now, I see this with a point of view that there are certain similarities when we look into the judicial approach, and especially when we rely to the fact that whether a practice is essential to a religion or not, or to call it an essential religious practice, the approach is absolutely same. That any practice would be allowed only if it is essentially considered as essential to the religion, and it, if not practiced, then it would be a trouble for the religion, or it would cease, the religion would cease to operate if that particular practice is not followed. But this is a similarity that is there that we can find out between the judgments of triple talaq, sabrimala, and hijab. But there's a difference between these two judgments broadly. Triple talaq and sabrimala were about breaking the cages. Breaking the cages as in the protest, the claims were with regards to that there is a foundation, there is a restriction that is put on us, and we want to be freed from that particular restriction. Breaking the cage. Women not allowed to enter the temple, Sabrimala temple, the women from 10 to 50 years of age group, restriction removed. Triple talaq, considered to be discriminatory, gender discrimination, derogatory to the dignity of women, declare the practice to be unconstitutional, declare the practice to be banned. Triple talaq declared as violating the constitution and banned. But in this case, the claim was that we are not allowed to do something, we are not allowed to wear something, and we should be allowed to do so. So yes, the three judgments, all these three, if we rely on these three, we look into these, it is about the women rights. The claims have been with reference to that, but the judicial approach is same. When we talk about identification of an essential religious practice, the judicial approach is absolutely same when it comes to protection of women rights, when it comes to renouncing those practices which are derogatory to the dignity of women. But it is different in terms of hijab when we come to the consequences, or when we come to the impact, or when we talk about what has actually exactly happened in a particular case. So in hijab, the court said you cannot claim it as a right while you are going to the school, and you have to abide, you have to follow the prescribed uniform. So we can say that the reliance of the court with reference to identification of women rights and its balance with the right to religion, freedom of religion, is the same. The approach is same. The only difference being the claim was altogether different. The claim in triple talaq and Sabrimala was about breaking a particular cage or stopping a particular practice which was considered to be derogatory against the women. In this case, if we look it from that point of view, the court first of all found that it is not an essential religious practice, and the court also said that it cannot be considered as derogatory if the women or the girls are asked to go to the schools without hijab. and this is a very, very substantial question which has been raised, or the court is alleged to with this regard, that what are you doing actually? You are asking the Muslim girls to go to the school without hijab. Isn't it derogatory to against them or their dignity or their modesty? Absolutely no. And the court said this relying on Quran. What Quran says? Quran in this regard says that you have to dress in such a manner which is modest. And the Quran, the specific quotations which have been cited in the judgment itself, over there it is said that a religion cannot mandate anything. A religion cannot make any such kind of clothing as mandatory. And therefore, the court said that when your religion is not making something mandatory, when your religion is not, when the Quran, the religious text, is not making something mandatory or essential, then how can you claim it as your right? So I find this similarity of judicial approach in terms of the previous two judgments related to women rights and the balance or relation or interface of women rights along with freedom of religion, and this particular judgment of hijab.
Okay, sir. So coming to the another question, that it has been alleged that the judgment is likely to significantly impact the Muslim women's education in India. What is your takeoff on this?
I see it from the point of view that it cannot be said as, first of all, if we look into the fact, we have been hearing a lot of public discourses by political leaders, by the legal experts, and people have been reacting on this particular judgment in the reference to that why this particular issue was never brought into public discourse or was never taken to the court of law from these many years. And is it that the women since so many years have been, Muslim women, Muslim girls have been going to the education institutions only wearing hijab and not without that? So these are altogether different questions to be considered. But if we say that this judgment is adversely going to impact or negatively impact the overall outcome of Muslim women going to the schools and the dropout rates likely to be increased, etc. This is a social issue. This is a social problem which we can say, if at all it is considered, and if it is brought into the limelight and people are claiming this, that the judgment is likely to adversely impact the number of Muslim women or going to impact the Muslim women education in India. So there are few points to be considered over here. First of all, we cannot say that all the education institutions of India allow or ban hijab, both. We cannot say that all education institutions in India allow wearing of hijab. For example, private education institutions, no. For example, certain other education institutions that we can consider as aided or unaided, not all of them. If we talk about the government colleges and schools or education institutions of Karnataka, yes, they have prescribed it and they have said that no, not allowed. So we cannot say that all education institutions have been allowing or will allow or are allowing, the practice of wearing hijab and only allowing the Muslim women to go to the schools when it comes to this. This is being said that the court would have considered this particular aspect. The court should have, looked into this particular perspective, that this is going to adversely impact the women education, Muslim women education. First of all, this particular claim did not find a place nowhere in the petition. The petition was completely based on one substantial, important constitutional question, and that was whether the practice of hijab is an essential religious practice or not. And the complete claim was in and around that particular constitutional question. So the court had to decide whether it's an essential religious practice or not, and the court said, no, it is not. So this particular claim did not find its place anywhere in the petitions that were, made by the petitioners in the Karnataka High Court. And then second, we also have to see that if this would have been allowed by the court, considering this particular social aspect, then despite the fact that it is not an essential religious practice, keep this in mind. If the court would have allowed this particular practice of wearing hijab in education institutions as a right, as a matter of right, despite the fact that it is not an essential religious practice, then how can court or how the government stop the people from other religion to wearing different kind of clothes or different colors which are associated or affiliated to their religion? Then there would have been no constitutional rationale to stop them as well. Because if you are allowing one non-essential religious practice as a matter of right, then you have to allow the others as well. And this particular issue can be considered, if at all it is said that, based on the numbers, based on the data, and significantly increasing of dropouts as few are eligible, then this is a negative social issue which we cannot consider the court to recognize. And we cannot, for the sake of recognizing a negative aspect, the court cannot, violate the constitutional norms. So it is not right to say that it is going to impact the, Muslim women education. Also, there I have, seen that few legal experts, even who were involved as petitioners and respondents in the same case, they had the battery of senior advocates, which we can say, they had also, in the petition itself, they had also relied on the fact that the constitution also allows to make your own education institutions as a matter of right under Article 29 and 30, to establish your own education institutions and to run and administer them as per your own religious affiliations. And the constitution will protect it. So these are few things which we can say the constitution keeps in mind the protection which should be given to the concerned authorities, to the concerned religion, such as an exception of carrying kirpan given to the Sikh because of the necessity, such as the right to establish and administer education institutions given to the minorities under Article 29 and 30. And at the same point of time, the same constitution also looks into the fact that opening or allowing Hindu temples for all the classes under Article 25, Clause 2b, allowing or opening the Hindu temples for all the classes, considering the fact that the Varna system, the class issue, the caste issue has been in existence in the pre-independent India, and even after that, the Constituent Assembly or the Constitution also recognizes this. So we can say that the Constitution has taken care of a balance between all of these, and the court is bound to follow the constitutional norms, and therefore it is not right to say that the judgment is going to negatively impact in this regard. And since, as I said earlier, I'm repeating the same, if it is so, it is a negative social issue, it is a negative policy or social issue which the courts cannot give recognition through violation of constitutional norms.
Okay, sir. So, proceeding further, I would like to extend my heartfelt gratitude to our esteemed guests, Sir Abhinav Shukla, sir. So thank you, sir, and a wide round of applause to all our participants who joined us in the live session. And also, finally, I would like to thank all of you, those present here, for making this session successful. Thank you.
Thank you.